We've actually just got some breaking news out of Colorado. We're going to stay with Kristy Greenberg and Hugo Lowell to talk about it. The Colorado Supreme Court ruling that Donald Trump has now been disqualified from being on the primary ballot for the GOP. Again, this breaking news out of Colorado. Donald Trump, as we know, was fighting to be able to be on that primary ballot. The Colorado Supreme Court now issuing a 200-something page opinion that we've just got. And we're going to go back to Kristy Greenberg and Hugo Lowell. I know, guys, you haven't had a chance to look at it. We're looking at it right now. It's 217 pages. But, Kristy, I want to start with you on this particular issue. This is not the first state that there's been an attempt to be able to disqualify Trump being able to be on the ballot. But what's intriguing about it is that it's now being done in a way where the judicial system is having a say in terms of whether or not somebody can be on a ballot. Your thoughts about what we're hearing coming out of Colorado at this time?
Well, it is an interesting decision because the Colorado district judge, Sarah Wallace, last month, when she made her decision, she had a really puzzling decision where she found, based on the evidence, that Trump had engaged in insurrection, but essentially said, well, Section 3 of the 14th Amendment, it doesn't apply to presidents. He's not an officer such that it applies to him, which was a really odd result. So when that was appealed, I think a lot of people had been scratching their heads and thought the appeal was appropriate. And, you know, I haven't read the basis of this, but it sounds like at least the Colorado Supreme Court said no. Actually, if he engaged in insurrection, yes, he is an officer, and the 14th Amendment would apply to him. It would be a perverse result otherwise to have it apply to members of Congress and others in lower elected officials and not to the president of the United States. So it sounds like Colorado Supreme Court got it right in finding that this should apply to the president and presumably determines that the factual findings of the district court in finding that he engaged in the insurrection were upheld. So it is a result that is interesting. It is a result that seems like the right result. The big question will be whether or not it holds, because this is surely going to the U.S. Supreme Court. And I have a lot less confidence that the U.S. Supreme Court will decide that Donald Trump should be disqualified from the ballot, given that conservative majority on that court.
I also want to bring in now former federal prosecutor and the host of the podcast Justice Matters, Glenn Kirschner. Glenn, again, I know that this is literally just coming across the wire right now, but I want to bring to our viewers' attention something that's on page 8 of this 200-page opinion. This is what the Colorado Supreme Court has held. 1, Section 3 that Kristy was just talking about, Glenn, encompasses, Section 3 of the 14th Amendment, let's be clear, encompasses the office of the presidency and someone who has taken an oath as president. On this point, the district court committed reversible error. And so it's cleared up that issue of how can you be the president of the United States and not be deemed to be an officer for purposes of your oath. In addition, Glenn, the district court did not err in concluding that the events at the U.S. Capitol on January 6, 2021 constituted a, quote, insurrection. The district court did not err in concluding that President Trump engaged in, and that's in quotes, that insurrection through his personal actions. And then President Trump's speech inciting the crowd that breached the U.S. Capitol on January 6 was not protected by the First Amendment. Glenn, we've been talking for days, if not weeks, about this idea of Donald Trump trying to hide behind the First Amendment to be able to give an excuse for what is otherwise going to be clear criminal conduct. Your thoughts about what this Supreme Court kind of ruling has now said as well?
You know, it's interesting, Katie, because all along it has felt like anybody with a basic understanding of the English language would read Section 3 of the 14th Amendment and conclude that Donald Trump is disqualified from serving in the event a court found that he engaged in insurrection. And what's really interesting now, getting down into the legal weeds a little bit, you know, the Colorado trial court found as a matter of fact, after a trial on the merits, a trial at which several witnesses testified, expert witnesses, witnesses who were at the Capitol that day, found as a matter of fact that Donald Trump engaged in an insurrection. And the reason that's so important as the case works its way through the appellate system now is factual findings like that are ordinarily given great deference in the appellate courts, because only the trial court judge gets to see the witnesses as they testify, assesses their demeanor, and reaches factual findings. So the fact that the trial court judge, in the estimation of the Colorado Supreme Court, got the legal conclusion wrong, and the Colorado Supreme Court basically reviewed that de novo from jump and reached a different conclusion. That's one thing. But the fact that we have these factual findings from a trial court should, frankly, continue to win the day up through the appellate court system, up to and including the Supreme Court. Because as long as those factual findings are supported by evidence of record, and they were, this is going to be a real danger zone now moving forward for Donald Trump.